The young ones are the best ones. That is a real quote from inside Meta, and it is now evidence in a federal courtroom in Oakland, California. Meta is on trial, accused of deliberately engineering Instagram to addict children, and then lying about it to parents and to Congress for years. The states suing want $1.4 trillion. Not billion, trillion. And here is the part that should stop you scrolling. Meta has already lost this argument twice this year in front of 2 separate juries. This is the 3rd time. Here is what they actually did in their own documents.
Let's be precise about the accusation, because it is not vague. California, along with 3 other states, alleges that Meta intentionally designed its products to addict children, that it knew, that it studied it internally, and that while it knew, it told parents its apps were safe, told politicians its apps were safe, and kept mining underage users for data that made it money. That is the claim. Not that harm happened by accident, but that the harm was the product working as designed. The trial opened on August 18th in federal court in Oakland, and the states are not asking for a fine. They are asking for $1.4 trillion.
Now Meta's defense. And I want you to sit with how strange it is. Meta's central legal argument is that social media addiction is not real. Their lawyers have argued, across years of filings, that because social media addiction has never been formally recognized in the DSM, the diagnostic manual doctors use, the claims against them must fail. In their words, the absence of a listing is fatal to the state's core claims. So the defense is not, we didn't do it. The defense is, the thing we're accused of causing does not medically exist. And they have pushed that argument so hard in court that at one earlier trial, attorneys hammering witnesses about the missing diagnosis appeared to visibly annoy the jury.
The judge did not buy it. In her June order, the judge wrote that the scientific literature and Meta's own internal documents use terms like addictive, excessive, problematic, and compulsive use interchangeably. And then she declined to draw lines between those terms. Read that again. Meta's own documents describe the behavior their lawyers say doesn't exist. The judge ruled that whether social media addiction is real is a material dispute of fact, which means a jury decides it, not a judge, and not the DSM. Meta has also filed a motion trying to stop jurors from ever hearing the $1.4 trillion figure, calling it a staggering number and unprecedented. They are fighting to keep the price tag out of the room.
And this is why Meta is fighting so hard. They have already lost. Twice. Earlier this year, juries in Santa Fe, New Mexico, and in Los Angeles both concluded Meta's products were harmful to children, in verdicts handed down just hours apart. In the Los Angeles case, the jury found Meta and YouTube negligent and apportioned the blame. Meta, 70% responsible, YouTube, 30%. The damages themselves were small. $375 million to New Mexico, $4.2 million to one plaintiff in Los Angeles. Then in August, a New Mexico judge ordered Meta to pay another $567 million on top, ruling the company was a public nuisance. Meta is appealing, but the verdicts matter more than the money, because they establish that a jury, shown the evidence, sides against Meta. So what does $1.4 trillion actually mean? For scale, Meta's entire annual revenue is a fraction of that. This is not a cost of doing business fine, the kind big tech absorbs and moves on from. A judgment at that scale is an existential event for the company, and Meta knows it. In its July 29th earnings report, Meta told investors in writing that the 2026 trials could significantly impact its bottom line. When a company warns its own shareholders in an earnings filing, that is not legal posturing. That is a company telling the people who own it that this might actually hurt.
In fairness, here is Meta's side, stated properly. Meta argues it genuinely cannot keep very young children off its apps, which is a real technical problem no platform has solved. It argues there is evidence its products are good for older adolescents, not just harmful, and that the research is genuinely mixed. It is appealing both verdicts it lost. And on the DSM point, Meta is technically correct. Neither of the 2 definitive diagnostic manuals currently lists social media addiction as a disorder. That is a true statement.
The question the jury has to answer is whether it matters. Because a diagnosis being absent from a manual is not the same as the harm being absent from a child. Manuals get updated. And the manual is not the evidence. Meta's own internal documents are. Here is why this case matters far beyond Meta. For 20 years, platforms have been effectively untouchable in court. The defense was always the same. We are a neutral platform. We just host what users do. This trial attacks something different. It says the design itself, the infinite scroll, the notifications, the recommendation engine tuned on kids is the product. And the product is the harm. If that argument lands at this scale, every algorithmic platform is exposed, including the one you are watching this on. That is the real stake, not whether Meta pays, whether we just built the feed stops being a defense. So tell me in the comments, is designing something addictive the same as causing harm? Because a jury in Oakland is deciding exactly that right now. Subscribe. I'm covering the verdict when it lands.